I just thought of something else when we were talking about the initial email question
Right.
with a person that was involved in a wreck, and I don't know if I believe the person was driving under the influence. I assume they were driving under the influence. It said there was an injury claim and there was a crime. So
Yes, sir.
it sounds to me it was driving under the influence.
Right.
Now, I didn't realize this until I really started getting into practicing law because I never did criminal defense. But not only can you be charged, if you're charged with DUI, there's not only a criminal process, but there's also an administrative process.
Yes,
What's the difference between the two, and what do people need to know about those two courses that tend to run kind of parallel?
Absolutely. So the criminal side is pretty self-explanatory. A person is arrested, they're brought to jail. Within 24 hours, they go in front of a judge to have a bond hearing. We call that first appearance, and then you go through the normal cycle of a case prosecuted by our state attorney's office. But as Les was saying, there is an administrative side as well. So for example, presume that a person is pulled over for driving under the influence and they choose not to submit to a breath, blood, or urine sample. Administratively, the Department of Highway Safety Motor Vehicles will immediately suspend that license for 12 months. If a person were to have a prior refusal to submit to a breath, blood, or urine sample, and they choose to refuse again, now their driver's license is administratively suspended for 18 months, but they're also charged with a misdemeanor crime for refusing to submit to that requested breath or blood or urine sample. So there is an administrative hearing that is held by the Department of Highway Safety Motor Vehicles. And I don't want to necessarily use the term it's a joke, but quite honestly, it's the Department of Highway Safety Motor Vehicles reviewing the Department of Highway Safety Motor Vehicles. They rule in favor of themselves literally probably close to 99% of the time. But there are occasions where it can be good as a criminal defense attorney to have that hearing. For example, in misdemeanor cases in Florida, there is no presumption that a criminal defense attorney may conduct depositions. In a felony case, yes. In a misdemeanor case, we need special permission from the judge in a criminal court proceeding. So some criminal defense attorneys will do an administrative hearing knowing that that officer who wrote the ticket, that case agent, is going to be there testifying. So the criminal defense attorney will hire a court reporter to be there. And now you're basically getting a free deposition. So you may not go in there expecting your client to get his or her driver's license reinstated, because quite honestly, if they refuse to give a breath, blood, or urine sample, the law does state that their license is suspended. But it does get the client a 42-day driver's license while they are waiting for the hearing to occur. And it also is a tool to give the defense some insight that they may not otherwise get in a misdemeanor case. If it's a felony, the rules allow us to depose just about anybody, which, again, is unusual. Florida is one of only a handful of states that still allow criminal depositions. So, two very different things. You can win your administrative hearing and lose your criminal case and be convicted of DUI, or vice versa. You could lose the administrative hearing and be found not guilty at trial. They are completely unrelated, different courts, sometimes different attorneys. It really varies.
Very good. And that was going to be my question. If you refuse to submit,
yes, sir,
you lose your license administratively, and that's regardless of whether you're convicted on the actual charge.
Yes, sir.
The refusal gets you the suspension.
Right. And the kicker is sometimes people have already done, let's say, 10 months of that administrative suspension for refusing, and then they decide to enter a plea, even if it's a plea to reckless driving. If we are able to get our client reckless driving instead of a DUI, normally our judges and our state attorney's office wants all the bells and whistles of a DUI case, including a driver's license suspension. And so many of my clients will ask at that point, when we are presented with that option of reckless driving, hey, my license has already been suspended for 10 months because I refused. Does it count? No, you're starting anew. So if you get to a point where you know that you want to accept a plea to resolve a DUI, it is better for you to do it sooner than later, because if you wait too long, you could end up having no license for even longer than a 12-month period. But check on a hardship license too, and that's something the criminal defense attorney can help.
What is a hardship license, and does a person need to have an attorney to do that, or is it good for them to have an attorney in order to get that? Or
sure.
Kind of explain what that is.
Absolutely. So it is possible under certain circumstances to receive a hardship license. The Department of Highway Safety Motor Vehicles sometimes refers to it as a business purpose only license. Now, if you have a prior DUI, you are not going to be successful with getting a hardship license. So the key is to have a first offense DUI. Otherwise, you're going to have some problems with getting one. It is definitely helpful to have an attorney, and it is as simple as enrolling in a DUI school. You do not have to actually complete the DUI school before getting the hardship license, but you will need to at least have some type of proof that you have enrolled in a DUI school before you will be able to get a business purpose only license. But if you get one, make sure that you are only going to and from work, to and from school, to and from a doctor's office, because if you're leaving work and you're supposed to be going east to go to your home and they find you going west, they being law enforcement, you could be arrested for driving without a valid driver's license, and that does happen. So it is very important, if you're lucky enough to have a business purpose only license, to in fact follow the rules. But if a person has a second DUI, a third DUI, you might as well just come out and say it like it is. You're not going to be successful getting a hardship license. And I do know this because we have so many people from Alabama that come down here and visit us. My understanding, and I'm not licensed in Alabama, but my understanding is Alabama does not offer people a hardship license. So we will have people arrested in Florida who have an Alabama driver's license or Georgia driver's license asking, can I get a business purpose only license from the state of Florida? And sadly, the answer is no. You are not a Florida resident. You didn't have a Florida driver's license to begin with. You need to check with your home state, but for our Alabama friends, probably not going to get anywhere unless
Right.
something's changed.